Hello, everyone, and welcome to this webinar on good practices for ensuring data protection and privacy in social protection systems. What we'll be doing is we'll be discussing the topic more broadly, and then we'll be jumping into the case of Indonesia and going deeper to learn from Indonesia and kind of the process that they've been going through in recent years. So this webinar is part of the Aspects webinar series, which is a joint effort between GIZ and IPC-IG. And obviously it's hosted by socialprotection.org, whom we thank today. If we move to the next slide, the webinar we'll be discussing with international experts and stakeholders from Indonesia, and I'll be introducing them to you in a minute. And we'll be discussing the importance of the right to privacy and protection of personal data, particularly for the most vulnerable population. So in the context of delivering social protection programs and services. And we'll be looking at the application of the practical implementation guideline that has been developed, and I'll tell you about this in a minute, into the Indonesian context. So just to give you a bit of background to this webinar, about a year ago, SPIAC-B has kind of supported the development of a key issues paper on data protection and social protection in low and middle income countries, which kind of provided a bit of a broad overview, and we can give you a link to that paper now in the webinar chat you'll find. But we've now gone a step further, and that kind of issues paper has been transformed into an implementation guide, which is looking at good practices for ensuring data protection and privacy, specifically for social protection systems. And this is really important. Obviously, we're all aware that this is a very important topic globally, but kind of what's been lacking to date is guidance on what this implies for the social protection sector specifically. There's been quite a bit of guidance coming out on humanitarian action, kind of some of it from some of the big kind of international organizations, but also kind of more broadly, the CALP Learning Network, for example. But this is the first time we have some guidance specifically for the social protection sector that digs into some of these issues. And we're lucky enough to have the two of the three authors of this guidance, which is soon going to be launched beginning of October. Unfortunately, we're not able to share it yet, but it will be launched very soon. If we go to the next slide. So Ben Wagner and Jacqueline are with us today. If we go to the next slide, let me introduce them to you. So Ben is an academic who's been working on human rights and technology for a long time. He is one of the authors of this report. Jacqueline Stein-Kaempfe is currently a data protection specialist at UNICEF. She's a lawyer by training and previously working at WFP in similar positions. And Carolina Ferro is not with us today, but she's the third author of this forthcoming guidance. And then we're very honored and lucky that we can discuss the context of this guidance together with colleagues from Indonesia who've been kind of grappling with some of these issues for many years. So first, I'm very honored to present Pak Maliki, who's the Director of Poverty Alleviation and Community Empowerment at Bappenas in Indonesia. He's been working on the development of Indonesia's social registry for many years, and it will be kind of fascinating to hear from him on the process of interiorizing some of the concepts on data protection to that process which he's been guiding. We have with us also two colleagues from Dentons in Indonesia, lawyers by training, who've been involved in the development of a new bill which is being launched in Indonesia. So we have Andre Rahadian, and if we go to the next slide, we also have Mika Isaac Kriaza. And with us, we also have Pak Subianto, who's Chief Digital and Technology Officer at PwC in Indonesia, also a lawyer by training and with a kind of interesting focus also on cybersecurity. So there's a lot that we'll be able to discuss here. What we're going to be trying to do is to keep the discussion relatively simple so that it's accessible to kind of those who are already familiar with these topics, but also those who are starting to grapple with these issues. I myself, I'm a social protection expert. I've been working on social protection information systems. I am not a data protection expert, so I hope I can do this session justice as a moderator. Over to the next slide. Great. So just as a few reminders, those of you who've been watching socialprotection.org webinars will know this already, that you can use the Q&A function to type your questions. And it would be great if you could also state your name and organization, and if your question is directed to a specific speaker. And obviously, it would be fantastic if you could interact also on Twitter using the hashtag that you see on the slide. I think we're ready to start. If we go to the next slide. Thank you so much for joining, and I'm going to hand over to our first speaker, Jackie, who's very quickly going to give us an overview of why this is an important topic and some key pointers on kind of terminology and other aspects. So over to you, Jackie. Oh, we can't hear you.
Yeah, there we go. Sorry,
there.
The picture jumped away. So good morning, good afternoon, everybody, and thank you very much, Valentina. I would like to set the scene for this webinar by sharing or shedding some light on what is data protection and privacy actually, and why is it relevant for social protection. So next slide, please. So data protection is an intrinsic element of the right to privacy, which is a fundamental human right. The right to privacy guarantees freedom from arbitrary and unlawful interference, mostly from states originally, with matters of a personal nature. So it's directed to our privacy in our homes, our correspondence, property, but also our personal opinions or our personal information. This right is contained in the Universal Declaration of Human Rights, but it's also in mostly all national constitutions of the world. With data, it's a little different. It's our personal information, but data is in our computers and through the digital revolution quickly within seconds around the world. So the right to privacy, how it was originally, let's say, phrased, doesn't really work or isn't really fully accomplished with data. And this is why, let's say, data protection, put it very simply, was invented. So in order to fully enjoy the right to privacy relating to personal data specifically, there's an international conviction, and that's the international best practice, let's say, that the processing of personal data by the persons who hold this personal data, so the companies, governments, or also individuals to whom this data flows through the internet, needs to be actively protected and regulated. Next slide, please. So data protection is the regulation of the processing of personal data by companies, governments, NGOs, any legal entities actually, and other individuals, with the goal to mitigate the interference with privacy. And data regulation, Ben may speak a little bit further about this, basically says what entities can and cannot do. And it also, in particular, the GDPR has the idea of empower individuals with rights which are also enforceable to control their personal data better. Whether that is worked in practice in the GDPR is to be seen, but that was at least the idea. Now, it's very important to always keep in mind that data protection and privacy is always limited to personal data only. Personal data is any information relating to an unidentified or identifiable individual. So if we take, for example, a data set which has a lot of my personal data, like my name, my address, my telephone number, all of my friends, bank account details, health information, in one data set, and then we strip off that all the identifiers, which is name, which is address, which is passport number, all these direct identifiers, and then also all information which would make it possible to identify me. For example, if I have a very specific disease, which other people don't have, which is probably improbable, but anyways, then that data set would become non-personal data, and the data protection and privacy laws and regulations would not apply anymore. It's always important to keep that in mind. So in short, why is data protection relevant for social protection? Because social protection is about a lot of personal data and a lot of sensitive data. So what is social protection in short? It's a set of policies and programs. Next slide, please. Sorry, Fernanda. It's a set of policies and programs which are aimed at preventing or protecting our people against poverty, vulnerability, and social exclusion, with a particular emphasis on vulnerable groups. There are different types of social protection interventions, like social assistance, like social insurance, and labor market interventions. We in this webinar will be focusing more on the so-called non-contributory schemes, where the individual does not need to contribute for obtaining an assistance. So it's basically cash delivery to an individual without the individual paying any employment contributions, for example. So the personal data needed to implement these social protection programs goes through all different stages of this implementation. So and it also depends, of course, what type of persons you want to target. So if it's about the elderly or disabled persons with disabilities or the young. So in any case, just to give some examples, so you get a better feeling about this. So for example, at the needs assessment of a social protection program, you would be collecting very broad information by interviewing people in a certain region, for example, what their needs actually are. And that can go from, being a certain minority, from poverty status to even health conditions, many different things, right? So, but at that stage, the data is not necessarily personal, because you don't necessarily need to know which individual has which need in order to understand the general needs of the population, right? But that comes then in at the eligibility phase. So if you decide which entities, which people to target for a certain program, you need to know who has which attribute in order to understand whether that person is actually needs to be targeted in the program. So for example, whether it's a certain age or a certain gender, maybe also, or a certain income level, or other vulnerability statuses. Then again, at the onboarding level, you need to know that the person who you have targeted is actually the person who you're now registering in the program. For that, again, you need identifiers, like, for example, the passports. And if they don't exist, or other identification, if they don't exist, you need to find another way, like biometrics is something which is being discussed here. Then at the delivery stage, you need to be sure that the person that's now standing in front of you is actually the person which was registered. So again, you need to ensure that the data here is the one that you need, and you need to process this also to ensure that the program is delivered to the right people or the assistants. Monitoring, again, you would be looking at all the accounting records, the transactional records, let's say the records from, for example, the banks who have been delivering the benefits. And then each social protection program is usually supplemented by a grievance mechanism where just feedback can be provided, but also very sensitive information, for example, about fraud allegations or harassment or similar things can be reported. So that's particularly sensitive. All of this data is stored usually in the so-called management information systems. And because governments necessarily want to have a better overview of how to whom the benefits are being provided in a certain country, they are more and more getting integrated. So data about me, for example, in one system, but with other data in another system will be interoperable, and the persons who have access to it will know even more, let's say, about the individuals. And then there are the so-called social registries, which contain even holistic data, and our Indonesian colleagues will be speaking more about that, because that has been relevant in Indonesia. And the data therein is even independent from specific programs, but about potential attributes that could be subject to targeting. Next slide, please. So why in sum data protection is relevant for social protection? So we mentioned, first of all, compliance, respect for fundamental human rights is one point. Then social protection programs have the most very sensitive data and also very comprehensive data, partly covering the entire lives of people, in addition of the most vulnerable people in society, which have lesser means to defend their rights. So there's a need to protect them. Then poorly designed social protection programs may expose individuals to harm if the data falls into the wrong hands. So people who are minorities can be persecuted. Very detailed information also could be used for surveillance purposes, and the information, for example, about the diseases or other could be used to stigmatize if they're obtained by the wrong people, let's say. Then fourthly, social protection programs which are designed with focus on data subject rights will enhance the quality of the service by nature because they aim to serve the beneficiary. So if you design a program with the individual and the user in mind, and it's a system which is supposed to help assist the beneficiary, then naturally the entire program and system will be improved. And finally, transparent data protection, which also empowers individuals because it gives them right, will be creating trust in the citizens. So that was for me. Over to Ben with an overview over the implementation guide. Thank you.
Thanks for that, and thanks, Jackie, for the overview. I think it was extremely helpful, really, to understand the basics of how data protection can be implemented in these contexts. I'm just going to share my screen now, so you can hopefully see. So together with Carolina Ferro, who sadly can't be with us today, we developed this guide on data protection for social protection, and really trying to understand what social protection practitioners need in order to be able to implement data protection. And if there's one message that I can pass on beyond what Jackie's already said, and I think it's the most important message of this entire guide, it's that data protection and social protection are fundamentally compatible. They both strive towards the same goals, and they all strive towards similar objectives, which is to protect individuals within societies. And so this fundamental compatibility means that they can be brought together in ways that are productive and useful for both elements of that equation. So when we're talking about the guide specifically, we'll be talking today a little bit about what the purpose is of the implementation guide, why we developed it and why we developed it with colleagues, and very briefly also about good international practices, before then looking in a little bit more detail about how to implement these data protection programs in social protection programs. So first, to the purpose of the implementation guide. Why did we develop this guide? Well, we wanted to encourage and support governments in low and middle income countries. And again, there's many efforts going on here already. And again, the main thing that we want to emphasize is these things can go together. Social protection can be developed with data protection at its core, and it can be developed very effectively so. And in doing so, we try to provide something that's practical, specific to the social protection sector, and offer guidance, increase awareness, and support people on the ground. Because it's nice then when you have all of these academics like me flying around saying, it's very simple, it can all be done in a really easy way. We want to go a little bit further than that to just say it's really simple, it's really easy, but give concrete steps for people on the ground, how it can be implemented in practice. So that's what the implementation guide is for. And so we've really thought it with a sort of practitioner's first perspective to understand how it can be developed, whether that's managers or program staff developing this in different areas. And of course, we're also thinking about the humanitarian agencies who are supporting these processes and trying to make sure that we also think in support of not just the practitioners and the humanitarian agencies who are supporting them, but also the individual households who are participating in these programs, the so-called data subjects in the language of data protection, and really make sure that they benefit from the way in which we think about these things too. So social protection and data protection go together. This implementation guide can help support that process. So when we talk about good international practices, there's many different practices and many things we can talk about. I won't go into too much detail now because I realize we have a limited amount of time and you have many speakers which will also want to speak, so I'll try and keep myself brief. But very briefly, as you've heard already from Jackie, there's sort of a set of things that you can talk about, which is to consider in the context of the guide, the data processing principles, the data subject's rights, accountability, oversight and enforcement, international data sharing, and sensitive personal data. Now, I'm going to just mention sensitive personal data as well, specifically, because I find it particularly important. Social protection typically deals with groups in society that are more vulnerable than other comparable groups in society, because that's precisely the purpose of social protection. It necessarily wishes to target those individuals, those groups which need protection, which need support. And so because of that, social protection also stores some of the most sensitive data that is possible to store. So it's very important when you think about your social protection programs to please keep in mind that this sensitive personal data that you're using to target individuals is also very sensitive data for individuals' privacy. And so I would make specific reference to chapter 8, where we really go into detail about what sensitive personal data is, how to think about sensitive personal data, and really try to emphasize this point that social protection programs are inevitably, because of their nature, dealing with these sensitive personal dimensions. And as a result of that, please consider not just any forms of data protection, but specific data protection that covers sensitive personal data when you're working on social protection programs. So, of course, we're always asked, what are the risks of not following this? What is the risk of not doing this? So one of the examples that we go into in the context of the report is called data minimization. And data minimization is one of the key elements of data protection, which is you minimize the data to what's actually needed in order to ensure that you don't share too much data. And this is one very good example of a social protection case where too much data was shared completely unnecessarily, and then the data was lost. So in this case, you have an office which is asking for a small subset of the database in order to be able to analyze additional beneficiaries and understand how they can be supported. But to minimize the work involved in a sort of slightly, you could call it a little bit of a lazy choice, they didn't minimize the data properly, but they just sent the entire database on one CD, and 2 CDs, I apologize, and the data was lost. And this is the sort of thing that you would classically say in data protection is a data minimization failure, where once you stop taking steps to mitigate the process, you're very quickly in a situation that if you're not mitigating, if you're not ensuring that you haven't sufficiently reduced the amount of data, if you haven't minimized it properly, the breach has a much bigger effect. In the end, it was almost the entire UK citizenry that was affected by this. And these really are big breaches with big effects. So please keep in mind, whenever you consider these sorts of things, they have big effects on large amounts of people. And of course, we're talking here about families, but depending on the social protection data and the sensitive personal data stored, there can be even more sensitive data than this shared and lost. And this is putting the people who are already vulnerable because of their need for social protection at even greater risk. So if we move on to the next slide, when we're talking about how to implement this on social protection programs, again, we have 2 examples of how this can be done, but sadly, they're not the best examples. On the one hand, we're talking about working with digital technology providers, and then we also have the ability to promote, adopt data standards protection, conducting data privacy impact assessments, and applying these standards to social protection programs. Now, all of these are chapters within the report, so we really encourage you to look closely as soon as the report is published to really understand how this can take place. But of course, there are again risks, as I mentioned already. Another example is here we have a risk of automation, and it's very interesting and attractive to try and use automated mechanisms in the context of social protection. However, sadly, a lot of the time, this comes with all sorts of challenges. Now, in this case, we have the Australian scandal. It's always around scandals that we sadly have these examples, where you basically have automated calculation of social protection rates, which were systematically flawed, leading to many wrong decisions and many beneficiaries being harmed. And you also have a similar case in the Netherlands where the Siri scandal around the Siri algorithm, which led to all sorts of harms to the beneficiaries, where again, you're dealing with incorrect calculations made by automated systems that were then supported by legislative institutions. And again, you have a case of a social protection system designed to create social protection, which is not protecting those who are most vulnerable. This case was particularly egregious, as you can see, because not only does it violate human rights, as is acknowledged in the district court decision of The Hague, but also people became so in debt that they actually had their children taken away for them because they were no longer able to care for them. And that's an extraordinarily large harm being created by a social protection system that is meant to protect. And with basic data protection safeguards that should have been implemented, with basic human rights and technology safeguards, these types of harms would not have been created, which again is why it's so important to always consider data protection and social protection together. And we've included many examples now from OECD countries, or what some people would call the global north, precisely for the reason that there has been a greater implementation of many automated systems. And we think it's important there to acknowledge that the countries that we're talking about now, low and middle income countries, are starting to implement very similar systems. And they really have a choice to make the same mistakes that the OECD countries made or that have been made elsewhere in the world, or to do it better and acknowledge that they can actually be the leaders in developing social protection standards and really show how it's done properly. Thank you for listening. That's all from my side. I look forward to your questions and comments.
Fantastic. And thank you for closing on such an important question in terms of the choices that lie ahead. And in general, for giving us, both of you, such an overview in terms of why it's so important for social protection in particular. And if I may, I just wanted to add that sometimes yeah, it's not only about social protection being geared towards those who are most vulnerable, so groups who are most vulnerable in society, but also the phases in our life cycle where we are at our kind of greatest levels of vulnerability. So there's that double kind of compounding factor there. Fantastic. So I think we've had a great overview of what the guidance is going to be doing once it is available publicly, and hopefully it'll be helpful to many of you joining this call today. I already see a question popping up, which is really interesting, and we'll come to the Q&A after this second chunk of this webinar, where we're going to be debating what's been happening in Indonesia. So in this kind of debate part, I'd like kind of all of the panelists to be turning their videos on. We're going to be having an informal discussion here. And to start with, I would like to invite Pak Mika, Pak Andre from Dentons, and Pak Subianto from PwC to give us a bit more understanding into what has been happening in the Indonesian context. What does your data privacy and protection regulatory framework look like at the moment? And what is the status of this new bill, which kind of hopes to really enhance the regulatory framework on these topics in Indonesia? So over to you, to whomever feels like they first want to jump in for this question.
Hi, Valentina, thank you. So if I can give a short introductions on the current status on Indonesian law regarding data protections. We have Pak Maliki here and Pak Subianto, also the experts and have the authorities on that. But from the practitioner's point of view, we've seen that while we don't have the comprehensive regulations yet, it's still in the process. As you know, it's in the draft bill. Currently, we have several laws that protecting the individual data, but mostly to give the burden on the electronic system providers to follow. So you've seen that there is a law number 11 on 2008. We have government regulations regarding the protections of personal data in electronic systems that already in place. What's new on this bill that we expect is the obligations to protect data, but also on the existence of the data protection officer, which is crucial in this. And that's regarding the actual data protections. On the social protections, we don't have a specific laws. It will be embedded on the draft law, but we currently have the laws regarding administrations of populations, which is law number 24 in 2013, specifically characterize what are the personal data under Indonesian law. which is informations on the physical or mental disabilities, fingerprint, requirement of iris, all the information, signature, and other data that may have a deterrent effect to individuals. So that are the information that should be protected. And I think for the discussion purposes, what we've seen in this regulation is not solely informations that available to or not unauthorized use of informations, but more on the authorized use of informations, because we know Indonesian governments have a lot of program that provide subsidy to the minorities, to the low income citizens. We have a health program targeted for them, which is also directed to the vulnerable communities. And in the financial and banking, as Ben correctly mentions, we have a lot of information that might not really related to the program that they want to have, but should be given if they want to join. So especially right now, Indonesian national ID is also serving as a tax number. So income informations will also be there, even for when you want to open a mobile number or join the telecommunications activities, you still need to provide that as an information. So Ben mentioned that less data will become a better solutions to protect. Only necessary informations that required should be given or asked to by the companies or by the governments. So I think that information will be good for discussions in how we see the incoming draft of national data protections. I think that's where I'm going to start.
Great, thank you so much. And thanks also for starting to reflect on the implications for the social protection sector. And I'll come back to that specific question for Pak Maliki in a minute. But before, I wanted to give Pak Subianto and Pak Mika a chance if they wanted to add anything else on the content of the new bill and what will be changing in Indonesia from the regulatory framework perspective with the new bill.
Basically, like Pak Andre said, that currently there is no law that specifically governs data protection in Indonesia in comprehensive manner. Personal data protection is partially regulated and spreading in many different laws and regulations. Basically, from Indonesian regulation side, the mandate is to implement the Article 28G paragraph 1 of the Indonesian Constitution, which mainly stipulates that every person has the right to get protection of its personal or privacy. The legal framework for data protection currently in Indonesia mainly governed in electronic information and transaction law and the Ministry of Communication and Informatics Regulation number 20 of 2016 concerning the protection of personal data in electronic system. Basically, there is several main obligations that must be fulfilled by the electronic system provider in Indonesia according to the MOCI regulation number 20 of 2016, like registering their electronic system provider to the MOCI, having internal regulation related to protection of personal data, and obtaining sufficient consent from data subject to providing consent form. Well, regarding the status of the new bill, according to Mutia Hafid, as the head of First Commission in the Legislative, the data protection law will be enacted at the end of, within this month, basically.
Okay.
The last time we checked, the pending issues are covering the status of supervisory authority, detailed provision on exemption on personal data protection for public and security interests, the provision on rights of data subject, the obligation of data controller and data processor, processing of personal data, transfer of personal data, and provision of sanction. Basically, that is the the pending issues. But like I said, it should be enacted within this month, basically according to the latest news. Well, that's for me. Thanks.
Fantastic. And if there's any link you could share to the content of the new law, that would be fantastic in the chat for those of us who are following us from other countries. Pak Subianto, any other remarks on this topic?
Well, I think it's pretty well covered by Pak Andre and Pak Mika. I think fair to say that currently we are still at the early stage. Obviously, you know, the law itself is about to release, and hopefully, as Pak Mika said, it's really coming up next month or this next month, hopefully. And I think as Ben has mentioned, you know, that it's critical actually, you know, even if the law is being released or effective, there's still, it's just the beginning. There's a lot of work that needs to be done. I think Ben touched quite a bit. For example, I take notes like risk of not following data protection standards, the risk of actually, you know, whoever, especially I think the institutions, you know, whether it is private or even government agencies, tends to like to request for a numbers of informations which may not all be necessary. And this is partly because of the level of awareness, you know, like more data you receive or you collect, the more responsibility you need to actually make sure it is being governed properly. So I think essentially, I would say it's brought down to the elements of communication as well as education in terms of how the upcoming PDP law being able to get understood by the respective, you know, by the relevant stakeholders, and in particular the data subject themselves, which is the critical elements in the PDP law. Yeah, I think that's the one that I like to add. Yeah.
Oh, really important. And also the issue of enforcement again, which is complex in this context.
Exactly.
So let's shift kind of more directly into discussing social protection. And obviously to date, Indonesia has been working in the absence of that overarching kind of regulatory framework, which is being introduced with a new bill. So Pak Maliki, you've been heavily involved in the development of Indonesia's social registries and social protection information system over the years. How have you been addressing issues of data protection and privacy for the provision of social protection specifically in the absence of this overarching bill? Over to you.
Okay, thank you, Ibu Valentina. I would like to, in the beginning, I would like to say that actually this is our beginning of our policy on how we can build a socioeconomic registry. So currently, all sectors, or we can also say that each line ministers have their own data, probably by name, by address data. So it's like a personal data. Not to mention, so it's like Ministry of Social Affairs, Ministry of National Education, and also Ministry of Villages. So those data is used for programs purposes. So basically they use it for targeting purposes or for monitoring and evaluations of the programs. So because of actually we have the experiences on the pandemic COVID, where the impact of the pandemic is quite severe. And it's not only for the poor and also the vulnerable, but also the middle class of the population. So from this pandemic, we have a very good lesson learned. Yeah? So that we need to have one integrated data that can have some like integrated interventions of the programs that can interfere all the population that impacted by the shocks, especially during this time is pandemic COVID. And it is quite difficult for us to integrate the data because I think its line ministers also have their own law in protecting the data. So this is one challenge. The other challenge is that how we can actually build one integrated data without any says like overarching laws, because now the the new bill is still not yet finished. So that's why I think what we have now is that we already have several laws, as what the speakers previously mentioned, says Law 24/2013 on population administration, and then also the regulations on public information openness, Law 14/2008, that are said that all public agencies must provide also open access to public information except the personal data. So this is actually several laws that we can use for build our socio-economic registry. Even though there is no specific discussion on the social protection sectors on the new bill, but I think general guidelines, general normative in the PDB bill, I think it is also sufficient for us. So therefore, after this law, I guess this we also need to have like more implementable or more technical guidelines for all the line ministers to follow the new bill. So then all the informations that will be reflected in all the sectors that integrated through the all sectors can also protect the individual's privacy. So we haven't specifically discussed the bill concerning the socio-economic registry and its relation to the personal data protections with the Ministry of Communication and Informatics, but we have thoroughly reviewed that each articles and section in the draft. It has been stated that information provider how data will be used and also has the right to stop or refuse to publish the data except for the government administration purposes. Mm-hmm. And I guess the social protection is one of the purposes. So I imagine that we can use the more integrated data based on individuals, personal, such as the presenters, the first presenters mentioned, that we can use says like the economic status, the welfare economic status, to see whether they fit with the social assistance program or the employment program that we have in each line ministers.
Mm-hmm. Fantastic. And thanks also for highlighting the role of the pandemic and sort of recent trends in terms of increasing integration and interoperability, and how that also heightens some of the considerations around data protection and privacy, because that is a trend that we're seeing in many countries. As a reminder for anyone who doesn't know about it, there's the SPIAC-B Convergence Initiative, which is looking into these issues specifically and providing quite a few useful resources and country case studies on these topics. So if someone could put the link in the chat, that might be helpful to those in the audience today. And would it be correct to say then, Pak Maliki, that in the absence of that overarching regulatory framework, you were drawing on the specific laws and obviously building in some privacy by design into the provision of social protection, including, for example, through your data management standards? Would that be correct?
Yes, indeed. So we involved all the stakeholders, line ministers that we have. And one of the roadmap that we are going to build is how we can build these protections of the personal data. Mm-hmm. So this one have to be built, have to be finished by 2030, yeah, 2023, sorry. Mm-hmm. And have to be involved with the Ministry of Informatics, as well as the state-owned enterprises that they have their expertise on this one.
Fantastic. So you've got a long journey ahead. Are there any particular challenges that you're envisaging in terms of putting into practice and enforcing some of the provisions in the new bill for the specific objective of providing social protection?
I guess the new bill will support us to build this personal data protection itself. So it's not a challenge, but I think the most challenge is on how we can provide very technical guidelines to the line ministers or to the other stakeholders, because you know that when we talk or discuss about the integration of the program, it's not only that the social assistance provided by the government, but also the social assistance or that provided by, say, like religious-based philanthropic. So this is one challenge that we have to also build, we have to face, how to build this system or interoperate system that allow various stakeholders to use.
Absolutely. Okay, great. Thank you so much for that. And again, thanks also for stressing the importance of, yes, there will be an overarching legal framework, but then discussing and crystallizing what that means for each sector will be critical. And for the social protection sector, we hope that this guidance on data protection for social protection will be of support in that process. Because again, each sector has got very particular data protection concerns that need to be thought through and kind of specifically addressed. I don't know if anyone has any reactions, maybe Ben or Jackie, to what Pak Maliki was discussing, or shall I move to my next question? Great. So I wanted to broaden back to all of those of you who are based in Indonesia. You've been listening to the presentations from Ben and from Jackie on this new guidance on data protection for social protection. Do you have any reactions to the presentation by Jackie and Ben? Is there anything in terms of the guidance that you feel might be particularly useful to you and to other countries that are embarking on a similar journey? Any reactions on the presentations that you saw at the beginning of this webinar?
Yeah, I have a question actually.
Yes.
If we can do a lesson learned from what the EU already implement on the GDPR, we've seen that whenever we join the website or wants to register anything, we are being asked for on the cookies requirement how far we want to extend that. But again, if you want to join or you want to enter into that, sometimes you have no options other than to agree on. Of course, it's essentials informations only. If we click only on in necessary or essential informations, but how, because that's the implementations of that. There is no other ways not to disclose some of our personal data when we want to join. How can we learn on that then in implementing our bills that's protecting that information? Because for example, like Pak Maliki say, we already try to concentrate or to consolidate everything. For example, in the financial system, we have a trend now on the peer-to-peer financing, right? That's targeted for non-bankable society. But when you download that applications, the regulations is limiting the platform access, but they have the capability actually to get everything from your handphone. That technology that we need to see and protecting, and sometimes if that's the legal platform registered, it's okay, but for Indonesia that still have in the middle income countries, we have a good penetrations of internet and data, but low on educations on that. What should the government or us as the private sectors contribute on educating that? So that's my questions, and how these regulations can be more protective on the social society on that. Thank you.
Thank you so much. And let me bring that even further to the social protection angle. This is actually one of the hot topics that I wanted to be discussing in this panel, which is on informed consent and the extent to which people are truly giving informed consent when the consent itself is a condition for receiving, for example, a benefit or service. So if I could ask any reactions to that, and to the broader question by Andrea on what are we learning from GDPR being implemented in Europe. Yes, Jackie.
Thank you. So, of course, the cookies is a huge topic, and it's very unfortunate for all of us. But I don't want to get into that because that relates more, I think, to the private sector advertisement area of data protection, which it's discussable. So in the area of social protection or the government's processing personal data, I feel that that data protection regulation and also GDPR is quite useful because it strengthens the rights of the individuals vis-a-vis the government. So and what I would like to differentiate here is really the difference between the legal basis on the one hand and the information of the individual on the other hand. So the legal basis, like consent, is basically the legal framework of the organization, or let's say the government, to process the data. And there are several legal bases. Consent is just one of them. Information always has to be provided to the individual, but you don't have to process the data based on the consent. So differently put, the government would usually, and I think Andre mentioned this before, if I'm not mistaken. So the legal basis for the government to process data is usually not the consent, but it would be the public interest, for example. So it would be using personal data when it is necessary to perform a task in the public interest, which means also that there is no right of the individual to withdraw its consent. So in the moment that you provide your data, the government has it and would use it for these legally regulated tasks for social protection purposes. And in the GDPR, there is a right also to object to processing if there is a particular situation of an individual. But generally speaking, the basis for the processing would be the public interest, and the government would be, let's say, also trusted to use the data only for specific purposes that are then again be made transparent to the individual. So legally there's a let's say a little difference between the two. Over.
Fantastic. Does anyone want to add anything to that on the kind of this concept of the legal basis for using that data? Ben? Let me then add a question which is coming from the audience, just because it's on the same topic while we're discussing this. And it's coming from Martin Kind, saying, regarding consent, given that most people, myself included, do not fully comprehend the potential consequences of data leaks, how do we ensure the general public can make informed decisions and choices rather than just checking a box?
Maybe I can try to
Please.
respond to that, Valentin. Yeah, I think that's a very good question. And to be honest, this is also something that I think we should anticipate to come as well, you know, when the new law becoming effective. So I think essentially the law itself have already prescribed, right, the needs that the consent needs to be there. And I think it has to be specific. So I think the key is there is an expectation that the consents need to be clear enough for the data subjects to really understand, you know, what is the purpose of use of their data by whoever that's collecting them. Yeah. And second, I think links to my first points early on about education and socializations. I believe it is important for the data collectors, you know, to sort of set up a mechanism as well to facilitate the communications to, you know, whoever, whether it is customers' data, employees' data, vendors' data that they are taking on, to really understand, you know, what they're going to do with their data. And I think, I'm sure there will be questions raised by the data subject. And I think it's important for the organizations, whether it's governments, privates, need to anticipate that and actually taking a proactive step, yeah, to set up a communication upfront. Yeah.
Really
and I think the
point.
law itself is already there. I think there is elements of data there's a data controllers, data owners sort of concept that has been embedded in the law. Yeah.
Mm-hmm. And this it goes, to responsible data practices, and these are topics, for example, that humanitarian organizations have been discussing for quite a while. So thank you so much for bringing that up. And in fact, just as a reminder, especially in a context of increasing e-governance, for example, as Pak Maliki was mentioning, in the context of the COVID-19 response, very often many governments were drawing data from several government data sources and using those together kind of to target out or target in, decide who would be receiving assistance. And that's obviously, in many cases, it wasn't the original intended use of that data, but it was serving a public interest purpose, going back to the comment that Jackie was making. Anything else on this topic, or shall I continue with my questions?
Maybe just one thing if I can add. Oh, sorry,
Please.
Does anybody else want to go first? So I realize that there are a variety of different legitimate interests that are possible, whether it's consent or a legal basis or many other reasons, public interest. What I find challenging in all of these contexts is that if you're using data for a purpose that was not originally communicated to the public when the data was collected, it's very, very difficult to build trust with the public when you collect the data again in future. So you're putting yourself in a situation, even if you can say the law is fine, the data protection is fine, like we've set it all up, this is legally valid, where you don't need to expect the next time that you are asking the public to provide data, that they will do so to the full extent of the law and with full accuracy. And this, I think, is a big advantage of solid data protection frameworks. If you know how your data is going to be used, and if you can trust that it will be used in a good way, people are also willing to trust and share their data in a sort of a robust and understandable way. And this isn't normally the case if you're constantly saying, we collect this, we'll use it for this purpose, and next month we'll change to something else, and after that we'll change to something else. At minimum, you need to be communicating clearly to people why there's a need to change this, but much better is to find ways to only use it for the purpose that it's needed, or communicate at the time of the collection that it may be used for these other purposes in, let's say, an emergency situation, or when there's no other way to do it at short notice. And these are steps that can be taken, but they require a lot of communication and public trust. And without that public trust, you're just collecting junk data.
Absolutely. And that brings me actually to another topic, which I think is under discussed for the social protection sector. Is we often see statistical offices, kind of national statistical offices, involved in the collection of administrative data for social protection purposes, and that blurring of the statistical purposes of data and the administrative purposes of data, and the complexity there in communicating that and users understanding that, just as a note, a side note.
Can I add to that one?
Please.
I completely agree with that, and I guess we have to build a very good trust on the public when we are collecting the data. But I'm just wondering about, I don't know about how the right tips to the people. Of course, the socialization, education is also the advocations to the people. But sometimes when we collect the data to the to the households, and we say that this data is going for like distributing social assistance, sometimes the households give a bit false data, so they some of them tend to look poor, some of them maybe refuse to answer the questions. So is there any experiences on this case? So then we also can, I know we can build the trust, but how we can also have the truth informations from the households.
Anyone want to react to that? Beyond the fact that it's a very complicated issue, and that's partly why in social protection we often focus on collecting the type of data which is more verifiable and objective, and with kind of strong supervision and verification processes, including sometimes through exchanging data with other government databases to be validating Yes, and a comment in the chat on why universal programs that focus on the most kind of widely categorical indicators can be preferable from that perspective. Okay, let me move to the next question. Yes, please.
Of course. So I have an impression in general in social protection that, of course, I agree with this point that universal programs are better, but also there's a general trend in social protection programs in the last decade or so, or even several decades, to over-focus on fraud prevention and to really focus on finding these small groups of people normally who are trying to defraud or evade the system. And you can see in the example of the Netherlands that I provided that the attempt to prevent fraud really undermines the whole program itself and actually really harms the beneficiaries considerably. So you always need to find the right balance between, of course, their government public resources, they need to spend well, they need to spend reasonably. But ideally, you design the program in a way that it's difficult to defraud in the first place, rather than designing it in a way that you constantly need to chasing after your beneficiaries to work out how exactly much they should be beneficiating and whatnot. In the case of the Netherlands, for example, the government proposed that rather than having the general public first pay for different allowances and then be reimbursed by the government, that they would directly do the reimbursements with the providers of the benefits themselves. And so you take out a stream of revenue away from the individual, removing a fraud possibility in the first place, and just reimburse the providers directly. In this case, it's a childcare allowance. So there's no actual need for the individuals to have their benefits provided directly to them. And so by engineering the program in a way that fraud is not necessary, you avoid getting into a situation where you have to chase fraud and combat fraud in the first place, thereby in many cases leading to an undermining of the reason that these programs were correct in the first place. So I really think there's lots of possibilities of designing the program in also more data protection friendly ways, rather than sort of focusing on the way in which they might be defrauded in certain situations, which often will impact a far greater proportion of the beneficiaries than would otherwise be necessary.
Thanks. Great point there as well. And what I'm going to be doing, just to warn the panelists, is I'm bringing some of the audience questions in while we're discussing, rather than having a separate audience Q&A. Given that we're discussing trust issues quite a bit, I'd like to bring in this question from Gabriel Fernandez around humanitarian actors being distrustful of governments very often, and often unwilling to share data and information on their vulnerable groups that they're targeting during a crisis, and asking how this trust issue can be addressed in terms of also the sharing of data from humanitarian actors to government actors. And this is particularly relevant in those countries where humanitarian actors maybe are in fact predominant actors and are looking towards supporting the building of social protection information systems in the medium term. So kind of sharing data to be building those systems that will be sustainable over time. And I see Gabriel is adding some further comments here, but any reactions to that?
Can I have something?
Please, Pak Maliki.
I don't know about the case that you already have experience, but in Indonesia, I mean, in our case, we usually to have like more inclusive planning also and targeting system that in the process of our planning and also the program targeting, usually we involve the NGO and also the humanitarian organizations. And quite often that we share the information of the data of the beneficiaries of the programs. So this is quite helpful for us to see either those who actually excluded from our programs, or that whether we already also have the inclusion error in our programs. So basically, if we involve the organizations starting from the beginning, I guess it won't happen that they refuse to share the data. In our development of the socioeconomic registry, there is already a few NGOs that already offer to locate some of the disadvantaged or vulnerable peoples that never existed in our administration of data. So this is quite helpful for us too.
Fantastic, thank you. And I think that the figure also of the data protection officer will be helpful from this perspective, because very often there's a lack of trust that maybe that specific government institution will be able to uphold the data protection kind of principles and rights, or maybe especially in the absence of an overarching legal framework. And in fact, I mean, for governments where the overarching legal framework is absent, it's important also to get your heads round the specific data protection and policies of the international organizations, be it WFP, UNICEF, etc., the Red Crescent, Red Cross, and be aware of kind of where those legal boundaries are. But again, I am not an expert on this topic. I'm speaking from some of the experience I've seen, for example, recently in some West African countries. Anyone else want to react to that? Great. So I'm going to move to my next question that I was planning in the discussion. I wanted to, just before we move on to some more of the hot topics that we've already started looking at informed consent, I wanted to ask Ben and Jackie whether, what do you feel the guidance can be most useful for? Are there any examples that you'd like to make to bring that to life? Any particular useful pieces of advice you would have beyond the ones that you've already shared, based on how the guidance will be useful for social protection practitioners in enforcing and kind of including a better focus on data protection and privacy?
Jackie, do you want to go first?
Please go first if you want.
Okay, so in my impression, the real value of the guide, and I mean, we mentioned this already, but I'm happy to mention it again, is that it's practitioner driven. So it's really trying to understand the needs of the practitioners, the key stakeholders, to understand what sort of things they would need, what sort of things they would be working on and working with, and then take from a sort of as lower level as possible to start getting sort of straightforward, basic knowledge of how these things can be implemented in a systematic way, while always considering that social protection practitioners don't necessarily want to or have to care about data protection. It's not their primary concern. They won't have studied it for many years at university, but instead they'll be focused on really understanding and really getting into sort of the weeds of what it means to do data protection on an everyday basis from a sort of a more basic, straightforward perspective. And if we can support that in making it easily accessible, not just people with a law degree or not just people with like advanced data protection knowledge, then we'll be very happy, because I think that's the key challenge for lots of practitioners. They'd like to do more, but they're not sure how. And so this guide will hopefully make it a little bit easier to work out how to do that how.
Fantastic. Jackie.
Yes, and maybe to give some more examples on exactly this, which I fully agree with. So we actually really breaking down in the guide how the different data protection principles and obligations can be applied to social protection systems, and also how really a social protection practitioner needs to or can record them, yeah, in the design phase, but also in the implementation phase, so everybody can see how it is being implemented, and the entire team working on the social protection system design and implementation can understand the elements of the data protection principles which are actually being implemented. So we, for example, suggest a data management protocol which reflects all these elements and details. For example, how long is the retention limit, or what are the actual purposes for which the data can be used and shall be used, and also elements, the actual detailed elements relating to the sharing of the data. And we also provide some guidance on how to do a PIA, but there are, of course, like a privacy impact assessments, but there's, of course, a lot of guidance out there also from the EU. And what I also wanted to highlight finally is, I think, a very useful section on how to work with technology providers, because for social protection systems, you will be working with providers, which, I mean, already the management information systems nowadays will be probably most likely in the cloud. So you should be thinking about, and these are things that we encounter in our daily work, that the data is suddenly sitting in, I don't know, not anymore in Indonesia, but in the US or in other countries, or biometric identification systems, just highlighting a few simple points. Like, do you really want to hold all the super sensitive data in a server? I mean, not even in the cloud, but in a server in the government? Do you want to take that responsibility, or isn't it better, and that would be the recommendation, to hold it, to have it stored decentralized on tokens that the individuals hold, for example? So then a hacking of the database is not even possible. So they are very practical examples which are nourished from our practical experience working in the field with many countries and advising them. Over.
Fantastic. Thank you so much. And you've definitely been convincing. And what I can say is, again, as a non-data protection expert practitioner, I have already benefited from having the privilege of having seen early versions of the guidance. So with thanks to you, and hopefully it'll circulate widely going forwards. Right, so I'm going to come to the last section of our debate, and as you see, I'm incorporating some of the questions from the audience. I'll be incorporating another one in a minute, but first, the first question I wanted to ask you is conceptual, and to be honest, you've already answered it to some extent, but I'd like to hear in one sentence from any of you who want to come in an answer to this question. That we often hear the pushback, I mean, especially when I work in many of the countries that I engage with, that data protection and privacy is a high-income country obsession. It's a European obsession that is being exported to the rest of the world. It's sort of colonialism in new forms, and it's creating needless complications. So what would you respond to that, especially from the point of view of social protection delivery, just in one sentence?
I'll go, Valentina.
Please.
Well, I think in short, data privacy is actually a very critical subject, especially, as we know, we are undergo a digital transformations in different ways here. But for sure, data itself is actually very key when we talk about the use of digital, whether they are, a rich or I'm sure, even if you look at the penetrations of the mobile phones, right, it's everywhere. Yeah, so I'm sure, like the rich, the poor, everyone should have that, and they also interact with the banking system and so forth. So it's not really a high income issue per se, and the reason for that is driven pretty much by the digital, which is essentially affected, all the elements in the society.
Mm-hmm. And in fact, very often what is happening is leapfrog technologies in many low and middle income countries actually kind of having more advanced and more at the frontier solutions than many high income countries, posing new challenges. And anyone else with a one sentence on that?
Yeah, if I might add, basically in my perspective, privacy data generally is a basic human right. So that must be preserved, not something that be taken into consideration only to developed countries. Basically, so it is not right if it is issued by high income country, because it is a basic human right.
Fantastic. A perfect one sentence answer.
Can I go?
If I can add.
Yes, please.
Pak, silakan Pak, silakan.
Oh, okay. Terima kasih Pak Maliki. So I think we know that all aspect of our life is on digital right now, and it's on all society, all class of society. So I agree that we need something or regulations to govern on how we protect our informations, but also still give a government access to it in case of like what we experienced in the past 2 years, we have problems in consolidated data. So the strike of a balance between privacy and disclosure is important in this incoming law.
Exactly, absolutely, and then that's also what Ben was stressing, is that there ultimately is no trade-off between the two, and we should be bringing the two together. Pak Maliki, over to you.
Yes, I guess from the government point of view that we have the obligations to provide the best possible protections of our individual data. In the same times, the utilizations of the data have to also provide the most optimal benefit to the people.
Fantastic. Thank you. So I'm coming to another controversial topic, which is on automated decision-making and profiling. And I'm just thinking about the use of some of those fraud detection tools that Ben was mentioning, proxy means tests. Where do we draw the boundaries on what is appropriate and proportionate and what isn't when it comes to data protection and privacy? And in fact, let me bring in a question from the audience in support of that, which is, do you consider it ethical for a social agency or a ministry in charge of social protection to be exchanging traceable data with private actors such as banks that have their own traceable data, which could be important for better understanding of socioeconomic characteristics of potential beneficiaries? What is that, for example, an ethical use of data? And yeah, so the floor is open to answer those two joint questions.
Let's give Pak Maliki first.
I think that if I can say that if it is personal use, I guess that one is not ethical. But now we have a memorandum of understanding with the bank system, which is now Himbara, is that all the social assistance is transferred directly to the account in the banks. So basically, for the program purposes, supposed to be have the justification. But I think for the personal purposes, it's not ethical.
Thank you, Pak Maliki. Anyone else want to come in on this one?
I believe whether it's ethical or not, it is depends on what is the regulation said, basically. So if let's say the government want to share the personal data to other entity, which is banks, let's say, it has to obtain approval first from the data subject. If not, then it is not ethical to share the data with the banks. I believe that would be the answer.
Yeah, I think it will be back to the informed consent issues, yeah, on whether it's ethical or not. But we also face the reality that in Indonesia, for example, private entities might have more comprehensive data than the government. So it should be the other way around on the sharing. So government might need assistance from the private sectors on getting informations right for the programs. I agree that the program basis will be should be the basis on sharing of informations, but again, from law perspective, it have to be obtained consent from the data from the
subjects.
Data subject.
Right.
Yeah.
Yeah.
Pak Subianto or Ben or Jackie, anything you'd like to add?
I would say it is inevitable, you know, and the world is so converged as well, you know. So the reality is the customer is demanding, you know, will be like the one-stop shop, for example, which will involve, you know, numerous or more than one organizations, right? So the data is actually might be keep or share. I think it's something that is inevitable. Yeah. So I think agree with what Andre said. The key is that coming back to that informed concern. And this is also a critical part on how to make sure the data subject is really understand what they are signing on. And it requires, of course, the elements of support, from the organizations who collect the data to make sure that the data subject is really clear as well.
Mm-hmm. And obviously some of the examples that Ben was making kind of on the automated fraud detection are pushing the boundaries of that, definitely. And that is why they were considered, well, both unethical and sort of contrary to human rights. Jackie, over to you.
Yes, no, I agree with everything that was said. In addition, I mean, in the first place, the bank shouldn't even have any traceable data if the individual has not agreed to it. So that is hopefully an outcome which will be obeyed by companies and banks also once a data protection law is in place and the individual has not agreed for this data to be collected, other than my bank account information, right? So and then I wanted to come to the other question that you raised, which is actually an interesting one. And I'm going to make, I hope it's not boring for you, but I make a little more legal observation on it.
Go for it.
Because the data, I mean, it's not purely legal. It's just to say that, let's say the question about whether automated decision-making and profiling is ethical is not so much a data protection question in the first place, right? So what, for example, the GDPR says, and I don't know what the Indonesian bill will be saying about automated decision-making, is basically that profiles can be created by persons if the individual, of course, agrees. And then also automated decisions can be taken based on those profiles, like, for example, inclusion or exclusion, in the worst case, from a social protection program. If there is an opportunity for the individual to request human intervention. So if the individual then wants to know why this decision was taken, there shouldn't be a machine answering, but actually a person which he can interact with. No, so all of that is of course quite complex. No, first you need a law which says this, then you need an individual who's informed about that actually automated decision making is being used, and then there needs to be a process to interfere. So the question really remains, which is your question, if all of that doesn't exist, shouldn't it be in the first place the controller taking like an informed decision when to use automated decision making and when not to use it? And that's really an ethical question, which is not so much data protection related, but maybe dealt with by other laws, because it's not about the privacy of the individual being interfered with. No, it's other human rights of, social protection, basically. Can I get the benefit or not?
Fantastic. And I see an important comment in the chat as well, coming from Martin again, on important not to understate the role of democratic control here. And great that the chat has also been used as a semi-discussion forum. And thanks to those who have also been answering questions on the chat. So do use that as a digital trace of some of the interesting.
Can I also jump in on this question?
Please do.
Because I find myself in a strange decision there. It doesn't happen very often, but very, very rarely I get to disagree with Jackie. And so this is one of those small moments where I get to disagree, because for me, at least in my understanding of data protection is never really about data. Like it sounds like it's about data, but data is the least interesting part of data protection. The role that I see of data protection in society is about politics and about power. And who gets to control how data is processed and when and how is a fundamentally political question. And so, of course, you could design a data protection regime to make something legal or non-legal. And as you say, there's like questions of ethics and politics are very present there. So you can't say, would it harm data protection or not? But I certainly think that all of the questions that are related to automation in social protection are eminently political questions that would also fall under data protection regimes. So, for example, the Austrian case where there was a government agency that was involved in trying to process data and manage data in a certain way that was meant to be automated was decided by a data protection authority. And lots of these automated fraud cases were also decided by courts or data protection authorities, not because they fit into classical definitions of what we would call data protection, but rather because there isn't any other regulator there who would be the relevant authority. And so over the time, data protection authorities and other agencies expand their remit to be sort of like digital regulation agencies in lots of different areas, just because there's nobody else there who's competent and who's qualified to do it. And so in the end, data protection rules that sounds very like dry and about data and cookies and boring and nobody really wants to talk about actually become about the future of democratic governance and constitutional governance, because they're what safeguards individuals' ability to be able to protect themselves and support themselves. And it's nice to have all of these democratic rights. It's great to have all of them, but unless you can also put food on the table and unless you can look after yourself and unless you're in a position to be able to do that, those democratic rights are not so available to individuals. And social protection provides a key foundation for that. So if you take away somebody's ability to sort of to live and to put food on the table and to provide for their family, then a lot of the time, a lot of the high democratic rights that we talk about, also controlled by democratic systems, don't mean a lot. And so I think in a less academic and more practical sense, it's really about sort of focusing on data protection as the future of constitutional democracy as we know it, but that's maybe a slightly expansive way of responding to Jackie.
That's a big step. It doesn't sound like it's in contrast to what Jackie was saying, to be honest. I feel like I don't see you disagreeing. Yeah.
I tried hard to disagree. I really tried.
You didn't manage. Okay.
I'll try harder next time.
No, I think it's a good compliment, and I don't think anyone here in the group disagrees with you from that point of view. And I see endorsement from the audience as well in the chat. Great. So we have only 4 minutes left. And to be honest, I think kind of a lot of the key concluding kind of big points we've already touched on. So I'm going to be slightly cheeky and ask you one last question, sort of by merging two into one, and then kind of have a one sentence conclusion in our last minute. And just because there's important issues in these last questions around, first around cybersecurity and whether it's a real risk for social protection and how, and linked to that kind of is the recent push for using more open source solutions, does that help to ensure IT security more cost effectively? What your opinion is on this? And also around assurance tools for beneficiary registrations and delivery and the use of biometrics. We saw another scandal, well, kind of recently being discussed in Iran around the use of biometrics to control the use of hijab. And kind of, again, there's a lot that can be discussed here. We only have 3 minutes to discuss, but any swift reactions to this question before we come to a closure? Sorry, this is a bit nasty to be discussing this in 3 minutes. Or maybe we can refer back to the guidance, because these topics are discussed in the guidance, as is kind of automated decision making and profiling. They're all topics which are tackled separately within the guidance document itself. So I'm happy if the panelists say that's enough. Let's close the discussion here.
Well, I think
maybe very briefly. Oh, please, no, Subianto, please go first.
Oh, thanks. No, I thought that actually the cybersecurity risk is real, right? Because nowadays attackers are specifically, targeting the personal data, and this data are valuable, So I think with the increased use of the personal data, which essentially is being stored at the technology, so I think this cybersecurity risk is really go hand in hand as well. So in addition to, we talk a lot on the governance side of protecting the data itself. I think the cybersecurity is equally important, actually. It needs to be considered and addressed. Yeah.
Absolutely. In the US social insurance response, we saw quite a bit of identity fraud and cybersecurity kind of stealing of personal data information used to be appropriating funds in that response. Ben, sorry, you were also responding.
Oh yeah, and again, I think you see the really political dimensions here. So you were mentioning Iran, and there's also the cases in Yemen and elsewhere where there's really challenging biometric implementations linked to the ability to access social protection services. And there again, it's a question of how do you design the system in a way that do you need the biometrics? Can you use them? Can you do the system without them? And a lot of the time you find that there's ways to avoid using biometric identifiers or other different systems because they're sort of an extreme form of fraud prevention all of the time. And that's what they're designed in for, when perhaps just making sure that everybody has enough to eat might be more important than preventing fraud.
Any last reaction to that from Pak Maliki?
No, I totally agree, I guess.
Fantastic. So I'm going to bring this webinar to a close with a huge thanks. We've been grilling you with questions, both from myself and from the audience, and you've done an incredible job of responding to all of those. And I think we're all of us convinced about the importance of this topic, and hopefully curious enough to be waiting for the October launch of the data protection guidance that we discussed. In the meanwhile, maybe you could have a peek at the issue guide, which is already published on the socialprotection.org website. And for all of those who may be interested, as I said at the beginning, this webinar is part of the Aspects series, the joint effort by GIZ and IPC-IG, and there'll be a next webinar on economic inclusion in adaptive social protection on the 24th of November, so do join that. The recording of this webinar will be available, and we know that many of our participants actually watch the recording rather than join live. So do share that with your colleagues who may find this of interest and use. And thank you all for joining and participating, and a massive thanks to the panelists.
Thank you.
Thanks so much. It was a great pleasure.
Thank you.
Thanks.
Thank you very much.
Terima kasih.
Bye-bye.
Bye.